Welcome to the second video for Chapter 8, which covers two of the things that need to be signed at closing, deeds and mortgages, and covers what happens in the event of a breach, which prevents us from getting to closing. So at closing, the escrow agent, typically someone from the title company, will make sure that the deed is delivered and that the mortgage is paid off, and if the new buyer has a mortgage, which is the norm, the proceeds from that bank will be used to pay off the old mortgage. The escrow agent will make sure that all instructions in the document that the escrow agent has to follow are in fact satisfied. So any other liens will have to be paid off. Any other interest in the property will need to be signed off upon so that title could be conveyed. So let's talk just a little bit now about what a deed is. A deed is the document whereby somebody signs off on a sale saying, I'm giving to you my interest in the property. And some deeds might come along with additional promises, and a quitclaim deed does not. We're going to talk about the details of those in the next recording, so not even in this PowerPoint. But the basics of a deed are that it needs to comply with the statute of frauds. And to do so, it needs to identify the grantor, the seller, and the grantee, the buyer. It needs to convey clear words of grant, meaning I am giving this to you. The land involved needs to be adequately described. It should contain a legal description, not just a mere address. And we need to have the signature of the grantor. Now, the intent today of why we use deeds is so that they can be recorded in the county recorder's office. In order for that to happen, we need to have attestation or acknowledgement. There's a little bit of a difference between the two, in order that the recorder's office will, in fact, have the authority to record it. On the last slide, I talked about a deed in the context of a sale, but people use deeds to give away property as well. The most usual problem for gifts of real property is in delivery of the deeds. Remember, for gifts generally, that we need present or immediate donative intent, as we can evidence by the person's words and deeds, meaning actions, not the document. Then we have delivery, and delivery needs to mean immediate transfer of title. And there are three types of delivery: manual, constructive, and symbolic. When we're talking about deeds, we're talking about symbolic delivery. Now, there's a presumption that the delivery is valid if the deed is recorded or manually handed to the grantee, and conversely, a presumption of non-delivery if neither of those occur. And then acceptance also is presumed, but there are reasons why someone would want to decline property, such as emotional reasons or tax consequences, or perhaps there is a high risk of contamination and liability on the property. So the book gives you a hypo where a grantor says to someone, keep this safe and record it when I die, as they hand the person a deed. Yet the grantor continues living on the property, making repairs and paying the mortgage. This is kind of close to the Greenacre case, demonstrating the retention of a life estate in a painting. The book tells you this isn't enough for the gift of real property to be valid. Given the purported grantor's actions, it seems more that he intended a future gift, which would have to comply with the Statute of Wills. He didn't say, this is yours, I'm giving it to you now, but I don't want you to record it until later, which somebody might say for any variety of purposes. Perhaps they want the whole family to know that they've given something away. Nonetheless, this type of thing gets people into a lot of trouble. This is particularly problematic if the grantor continues to claim homestead exemption on the property for property tax purposes, or to keep the property away from creditors under statutory creditor exemptions. So when it comes to deeds, the context really matters, and one really big danger area is if somebody continues to live on the property and claim the homestead exemption. In Rosengrant versus Rosengrant, we covered that a lot in class, and I'm not going to do that in full here. But I wanted to note a couple of things for you. First of all, there's a safety deposit box involved. And people often do this with deeds so that two people have access, the person they're hoping to give something away to and themselves. And there were $10,000 worth of CDs in the safety deposit box with both Jay and Harold's names on it. And the way that that was treated was very similarly to a joint tenancy. There was a right of survivorship so long as neither party disposed of those CDs during their lifetime. But when it comes to deeds, the outcome is different. So if there's joint access to the safety deposit box in Kentucky, and this is the majority rule, both parties are entitled to the contents of the safety deposit box. But when it comes to the deed, because the grantor has the capacity to retrieve that deed, and remember, it needs to have the grantor's name and then giving it to the grantee. Because of that, it is not considered to be delivered just by giving somebody else the power or by key or signature to access that safety deposit box. The bottom line is that the grantor did not part with dominion and control. As to the envelope containing the deed, Jay did not know what was written on the envelope. Nonetheless, the words "to Harold or Jay" sounds like a joint tenancy. But it wasn't good enough, again because of the bank custom that would have allowed Harold to come back and get that deed back. So, let's talk about if the deed had been valid and delivered, Jay would have gotten the farm. But as the court found, all that we had from Harold was a promise of a future conveyance. That needs to comply with the Statute of Wills. To comply with the Statute of Wills, we need a few things, which I'll highlight on the next slide. Here are the requirements to comply with the Statute of Wills. Someone must be at least 18 years old, of sound mind, not under restraint or undue influence of another person or alcohol or drugs, which relates to being of sound mind. It needs to be in writing. It can either be handwritten or typed. If it's handwritten, it's called a holographic will, and the testator needs to sign it. If it's typed, then the testator needs to sign that will in front of two witnesses who watch the signature and hear the testator acknowledge his or her signature, and then they too also must subscribe, which is a fancy word for sign. A will is effective only upon death, and courts insist on using the Statute of Wills because there's so much risk of fraud where the person is now deceased and memories fade. So, talking a little bit more about Rosengrant. Let's do the problems applying it. So in the first one, we have, I have now transferred Greenacre to you. Give the deed back to me, and I will keep it in my bedside drawer until you graduate from law school. That's enough. That I have now transferred Greenacre to you are words of present intent. The next one also is good enough. I want you to have Greenacre, but I want to live there until I die. That's like keeping a life estate in the property, but title is conveyed. The next two are problematic. Here's my deed to you. Please hold it safe until I talk with my wife, and then you can record it when I say it's okay. That doesn't show present intent to convey, and even though it was handed over, it's not good enough. And then the last one is our safety deposit box problem. Place the deed in our safety deposit box, and when I die, Greenacre will be yours. That means it's not yours now. So let's now contrast a little bit what happened in Rosengrant versus Vasquez. Really, in my heart, I don't think they are truly different, even though the outcomes are completely opposed. I think if Juanita had gone to her lawyer and asked to get her deed back, I think the lawyer would have given the deed back. So I don't think she did truly part with all dominion and control, but the lawyer was never asked that question. So in that case, the court did say that by leaving it, she parted with all dominion and control. That's the majority rule for delivery of a deed via a third person to be valid and for the deed not to be void. And it doesn't matter if the party she's giving away the property to, the beneficiary, doesn't even know that there was a conveyance. Just like here, we had a secret conveyance. People might want to do that in order to make sure that something happens after they die, but they don't want to deal with the drama of their family in doing it. So as stated by the court, when a grantor delivers a deed to a third party without a reservation of a right to recall it and instructs the third person to deliver it to the grantee on the grantor's death, he thereby makes an effective delivery as a matter of law. So beyond that, a few states use the beneficiary deed, but it's a minority rule. And a few states use these revocable deeds, but wow, is there a lot of room for fraud in those. Pretty risky stuff. At the closing, the mortgage will be finalized. Most of us can't pay cash for the full purchase price of property, so we finance the purchase with a mortgage loan. Really, we can get the money by signing a promissory note to pay back the loan, in other words, be personally liable, and we give the bank a special document giving a lien on the property, which is called a mortgage. For at least the past 50 years, the traditional mortgage arrangement in the United States has been for the borrower, the buyer of the home, to come up with 20% of the price, the down payment, and get the loan for the remaining 80%. This is separate and apart from the earnest money given to the realtor when signing the purchase contract. The traditional loan would have a set interest rate, fully amortized, meaning with a consistent monthly payment over the full term of the loan, traditionally 30 years. If the borrower doesn't pay, the bank or other lender, if that's the case, has the right to foreclose on the mortgage and apply the proceeds of the sale to the promissory note. In other words, the property serves as security for the loan. If the property is under contract to be sold, the new buyer should do a title search that shows the seller's mortgage. Most commonly, the mortgage will be paid off in full with the sale proceeds coming from the buyer's mortgage company. If not, it is possible that the mortgage of the seller was assumable, which means the new buyer simply keeps paying on the mortgage and takes on personal liability for it, but those are much less common today than they were some time ago. If the mortgage is not assumable and the mortgage is not paid off, then the property is being taken subject to the mortgage. If payments are missed, the bank will have a contractual right to come in and foreclose upon the property. Further, if the bank realizes that the seller has sold the property, there will be an acceleration clause on the existing loan which says that everything is due on sale, and the bank could choose to accelerate the entire loan, meaning it needs to be paid immediately. If the current buyer can't do that, then the bank will come in and foreclose upon the property, but go after only the seller for the deficiency judgment if this buyer has assumed somebody else's mortgage. Over time, banks got more creative in how to set up mortgages and qualify more people to get mortgage loans. Today, some people are still able to get into a home with no money of their own, but it's really, really rare. And what you see quite commonly is somebody take out a first mortgage and a second mortgage. If they do it that way at the closing, they typically only have to put down 10% of the purchase price in cash. The first mortgage will be for 80% and the second mortgage will be for 10%. This will typically be done with the same bank, but if two different banks give these two separate loans, the second mortgage holder will get paid out of a foreclosure only in the event that there's something left after the first mortgage holder is paid everything that's due plus any penalties and fees. And there might not be enough to go around. Those penalties and fees are pretty expensive, and a foreclosure proceeding is a little bit expensive. So if either bank is shortchanged, then that bank will have a deficiency judgment to chase down the borrower's other assets like a car, or even get a percentage of their paycheck by garnishing wages. If property does go to foreclosure, most banks will make what's called a credit bid, which is for the amount they are owed on the mortgage so that nobody buys it for less. Then the bank will own the property and can put it up for sale, typically in a short sale scenario where it probably will take less than it's ultimately owed. Some states have passed anti-deficiency laws restricting the ability of lenders to chase people down for the total amount they owe forever. Kentucky doesn't really have one. So Kentucky has a very long statute of limitations on how long banks and lenders can go after people for deficiency. In contrast, California passed an extreme one that says that no lender can go after a deficiency if the property foreclosed upon was the borrower's primary residence. And California did this in the wake of all of that foreclosure crisis, which was such a disaster. And a lot of that was created because banks were able to qualify people for loans with so little money down and so little capacity to absorb any adjusting interest rates or even pay the basic monthly payment at the beginning. So there are other protections for borrowers to prevent banks from being able to get the property and then come after them for huge amounts all the way into the future. So for example, when it comes to foreclosure auctions, the lender better do it in a commercially reasonable way in terms of notice, advertising, location, and time, so that a reasonable number of bidders might be able to come and theoretically at least bid on that property, although banks are typically the only ones bidding at these auctions. Courts generally don't want to get into examining whether the ultimate price paid was fair. After all, few people have enough cash to buy homes at foreclosure auctions. So we're not talking about normal market price of homes as most of them are listed on Realtor.com. Nonetheless, there is a doctrine where if the price absolutely shocks the conscience of the court, that it can void the sale, but it's very, very rare. Now, like I mentioned before, mortgages can come in all different shapes and sizes. Another aspect that can be different is when banks issue what's called ARM, adjustable rate mortgages, so that in the beginning somebody can get into a house and have a low monthly payment because the interest rate charged in the introductory period is quite low. But after a set amount of time, which you usually see is 3 or 5 years, but it can be any amount of time, the rate will start to change in some relation to the market's then current interest rates, which will usually be higher. Additionally, a lot of these come along with the need to pay a balloon payment, so perhaps $10,000, $30,000, $100,000, or any other amount after a certain amount of time. And it may be, maybe it's 3 years, maybe it's 5 years. If the buyer can't come up with that balloon payment as they agreed to, and they can't get it some other bank to refinance the loan, well then they're going to get foreclosed upon. So a lot of these things contributed to the foreclosure crisis. A lot of people getting into homes that they really in the long run could not afford. Now, another thing you should know about is that there could be first and second mortgages, and then people can also take out home equity loans. If there's a first and second mortgage on the property, the home equity loan would be then third in priority. But the home equity loan is just like any other lien that could be asserted against the property. So I want to make another point here about acceleration clauses in promissory notes. If someone doesn't make a payment at all, they have a little bit of time to make it up before the bank triggers that acceleration clause. But once that acceleration clause is triggered, the entire loan is due and time is of the essence. The contract will have a little bit of a period where the buyer could go ahead and pay the amount in full, which is like a miracle. That period is called the reinstatement period. And then There's an equitable right of redemption, which arose in common law, that if the buyer could come up with the full price, they could get the property back from the mortgagee, and then the statutory right of redemption can even allow the buyer to get it back after some other buyer has bought the property at a foreclosure sale. In Kentucky, that can last up to a year. So that's an incentive for people to pay a fair amount of money for property at foreclosure. If the lender uses judicial foreclosure, the statutory right of redemption goes away. It does not apply. So, as I mentioned above, most states require that a mortgage works like a lien, right? A few say that when someone signs a mortgage, they are giving title to the lender. Either way, most foreclosures across the country are non-judicial foreclosures. When the buyer signs the documents, he or she gives the bank the right to foreclose upon the property without going to court, which saves on expenses. Most states allow this. In those states that don't, lawyers came up with the deed of trust, but courts are looking at those and sometimes implying or imposing some procedural safeguards in the name of equity, such as in the Wansley case, which we discussed in class. I want to note here a few of the less common things we discussed in class. First, it is possible for a sale to go through and the buyer still owe the seller some money. This is what's known as a seller-held mortgage, and it affects both parties' income taxes. Second is an installment land sales contract. These are sales where the buyer gets possession on day one and must pay the seller over time. Unless otherwise agreed, the buyer is regarded as the owner and gets the income tax deductions on the mortgage interest, assuming he or she is itemizing deductions. If the buyer misses any payments, the installment land sales contract typically provides that the buyer forfeits all prior payments. This is true even though the typical arrangement is for the buyer to pay all property taxes, assessments, water rates, and insurance. When someone is in the property in this arrangement, they view themselves as the owner, and they might even make significant improvements to the property. There is a high risk of litigation in using these in a residential situation. Courts understandably sympathize with buyers in residential installment land sales contracts when they forfeit a whole lot of money in equity upon missing one payment. The mobile home case really demonstrates how devastating these arrangements can be for buyers, especially if the seller is trying to push them out close to the end of the executory period. Here's another thing that a lot of people overlook in doing these. If the seller has a mortgage, the bank will have the right to trigger the due on sale acceleration clause if somebody signs an installment land sale contract. It's a sale. For these reasons, I don't like doing these for regular residential sales. I prefer, if a buyer can't qualify for a mortgage up front, but it's worth it to deal with them, to use a lease and then a fully separate option to buy. The owner is a landlord until the option is triggered. Then the owner becomes a seller. The owner keeps the tax benefits until closing, with no equitable rights potentially accumulating for the buyer. It's much cleaner, but the numbers have to make sense given each side's different tax brackets. Now, the last less common mortgage item that I want to discuss is the deed in lieu of foreclosure. This is when, instead of forcing the bank to go through the foreclosure process, the buyer in default on the mortgage simply deeds back the property to the bank. In this way, the bank avoids the cost of foreclosure, and the impact on the borrower's credit report is also less. Nonetheless, people need to be careful with these. It doesn't necessarily mean somebody walks away carte blanche. In many states, the bank can still come after the borrower for a deficiency unless the deed in lieu contractually states that the bank waives that right. The one I did in Kentucky, the bank waived the right for the first mortgage, but not the second. Nonetheless, I didn't have any risk because the way my financing was structured, My first mortgage was relatively low, so I felt confident that even after the deed in lieu process, when the bank did eventually sell the home, that the amount of the sale would more than cover the amount of the first mortgage. So I felt comfortable walking away and didn't have any exposure. The last topic I want to cover in this video is remedies for breach of a purchase agreement before closing. When one side wants the other to go through with the deal, that side is seeking specific performance. Specific performance is an equitable remedy. Long-standing jurisprudence says that equity is not supposed to act unless the legal remedy is inadequate. In real estate, we assume that every piece of real property is unique, which means we presume that cash is not an adequate substitutionary remedy for getting the actual piece of property. So specific performance is readily awarded as the remedy for breach in real estate cases. Nonetheless, the court should still look at balancing the equities and hardships and decline to award specific performance when they are extremely out of balance. Nonetheless, courts are very used to awarding specific performance in real estate breach cases so long as the home is already built. Otherwise, courts don't want to have to oversee the complex contract where the parties are so ripe to disagree over so many little things, such as the quality of the granite used on the kitchen counter. You saw in Giannini how the courts award specific performance even for condos, although there are a couple of cases out there that chipped away at the concept of every condo truly being unique. Perhaps in 50 years this rule will be different, but for now, condos and homes are treated the same for specific performance purposes. During class, we discussed the financial realities of the deal, which I won't repeat here. But I do want to make sure you got out of Giannini how easy it is as a legal matter to convert a building of apartments into condos. You just have to file a declaration of condominium with the county recorder's office to set it up, and then you can sell those individual units. There will be a condo board and some basic rules. From there, the condo board members, once elected, can make additional rules applicable to the property. So condos are basically the same as uniform subdivisions out in the burbs that have their homeowners associations. In the burbs, the homeowners association will have a board and also pass rules. They are simply established by filing a declaration with the county recorder's office. Also, balancing the equities is a different matter than the impossibility or illegality defense to a contract action. The court in Giannini seems to equate impossibility with its standard to put the brakes on an equitable remedy, but it seems motivated really by the desire to use equitable estoppel given how the bank had represented itself in the foreclosure proceeding. It said that it would follow through and convert the apartments to condos in that court proceeding. So what you have here is the court sort of confusing a couple of different contract and equitable defense issues, but I would like you to be a little more precise. In conclusion, this case shows you at a minimum how ingrained the norm is of using specific performance in a real estate breach action.